Aloha, everyone. Thank you for joining me on ThinkTech Hawaii. I am Chanda Park, your host for Money Talks. My guest today is Amphay Champathong, who is an attorney practicing in estate planning. Today, we're going to continue talking about the essentials of estate planning. Welcome back, Amphay.
Thank you, Shonda. Thank you, ThinkTech, for this opportunity to really share something that's important to all of our families.
So when we were talking about your introduction, I remember that you're saying, no, introduce me as Amphy. If you say Amphay, people are not going to know who you're talking about. So do you want to explain, because of the last episode, if it went out and people hear me addressing you as Amphay? The last time you shared a little bit about your background, do you want to share a little bit about the name situation?
Oh, yeah. So if I actually go by both, and if you knew me before the ninth grade, then it would be Umpai. If it was after the ninth grade, then it would be Amphi. The funny story to this is that the way it's spelled, it's if you pronounce it, it's like a PH, like it's supposed to be an F. So I remember every single year, every single new class that I had to go to growing up, I would have to always correct the teacher. So come ninth grade, I was having way too much fun in running around in Kalihi, and my parents decided that I needed to change schools. So picked two schools, two of the furthest schools from each other, and then I decided I was going to go to Kalani. And so my first day of class, not knowing anybody, I'm sitting there very anxious, and the teacher is reading the roll call, and then she goes, Amphi. One of my dear friend classmates that I, now I'm friends with, then one of the girls stands up and she goes, oh, you have it wrong. It's Fayan. And I was so embarrassed that I didn't correct her. And then from that point on, it was like, if Amphi was meant to be, that's the way it's going to be. And it's stuck ever since. And like I said, I'm fine with both names, Umpai or Amphi.
So Amphay was your given name.
Mhm. Like if you were in trouble, when somebody says Umpai, like, ooh, what do I do now? So
Yeah. So even for me, when I was introduced to you, I want to say about 10 years ago, I was you were introduced as Amphi, and you even referred to yourself. When you spoke about yourself, you said Amphi. So it took a while to make that adjustment after, like, I'm not sure, 8 years or so. So yes, I know that you go by both, but I wanted you to explain to the viewers. So on a more serious note, let's quickly review about what happens with no estate planning from our last conversation.
yeah, so I just wanted to kind of do a little recap from the last time we met. So we can have the first slide, please. Just so again, it's really to avoid, the time-consuming, costly court interventions. We're not going to go into any of this stuff because you can look at the previous episode, but it's to avoid probates, conservatorships, and guardianships. Next, we went over this as well, and we talked about the drawbacks, not only of probates, but also of the conservatorships and guardianships, and why what are the possible consequences in the event that we don't properly plan with regards to estate planning. So, and the purpose of the last episode is really to have us think about why it's important. In knowing the cost and all of the drawbacks, the hope is that now families would have a bigger appreciation as to why. And now moving forward, like what is an estate plan? What is a proper estate plan?
So when you say proper estate planning, what is proper estate planning versus what people think an estate plan is?
Like I kind of mentioned, it's really going, like, can we now keep everything private? Can we do it in a way where we're not seeking, someone else to provide us with guidance, approval, or direct what we want to direct. And it's going to the sense of control and of liberties. We want to control all the things that we've acquired in our lifetime for the benefit of our family. And when we think about leaving a legacy, we don't want it to be tainted. We don't want it to go, to somewhere else. So that's really the idea. So in the next slide, we're going to talk about what
people need to do. Yeah, what people need to do to have a proper estate plan. Not an estate plan that people think, oh, okay, I have one, and they don't really know what it is. But yeah, what do people need to do to set up a proper estate plan?
So let's talk about documents, right? Like what is necessary, what is needed in your estate plan. So as it states here, any basic estate plan should have these following documents. And all of these documents now, as a whole, will provide that comprehensive planning in that now we are not going to, they all have their different functions, right? And so this would be your revocable living trust, a certificate of trust, a pour-over will, a durable power of attorney, advanced healthcare directives, and finally HIPAA authorization. So all of these documents all together, as I mentioned before, they all serve different functions. And that if you are missing any one of these documents, there is a puka in your planning. And if the idea of creating an estate plan is to have peace of mind, we want to make sure that we have all of these documents in place. So if we can, I would like to kind of go over each one of these documents, explain a little bit about what it is and what it does with regards to your planning.
Okay, that would be great. So you're going to start off with the revocable living trust.
So
because there is a revocable and an irrevocable living trust, correct?
Correct. And that's actually a whole new episode about what type of trust. There are so many ways and so many different types of trust that we can design. So for the purposes of this section, I want to just focus on a revocable living trust. And the reason for that, again, is really the ability of the grantors to exercise control. Okay. So what is a revocable living trust? So a revocable living trust essentially is a contract, an agreement between three parties. You have a grantor, you have a trustee, and then you have a beneficiary. Okay, the grantor is the person that creates the trust. The trustee is going to be the individuals that administer the trust. And of course, beneficiaries are the people that are going to benefit from the assets and the proceeds from the trust. So while you're alive and well, if you create a revocable living trust, you wear all three hats. You're going to be the grantor, you're going to be the trustee, and you're going to be the beneficiary of your trust. The key to this trust working properly, though, is that it needs to be properly funded. So what does that mean? Next. So if you think of your trust like a bucket, the process of funding means that we are going to put assets into your trust bucket. This is what we call funding your trust. So now when you fund your trust, you individually don't own these assets anymore because you're already put into trust. So your trust is the owner of your assets. But like I shared with you earlier, because you're both the grantor and you're the trustee and the beneficiary of your trust, in essence, you can do whatever it is with the assets that you actually put into trust. So now, next.
And I've heard that term many times, that your trust is like a bucket. So thank you for explaining it in simple terms, because when you don't understand estate planning and you just hear your trust is like a bucket, you just put everything in your bucket. That term in itself is confusing.
Mm-hmm. So when we do estate planning, we do sit down with our families and we go over every possible asset that the families could possibly own, and then we will provide them with guidance as to what to do with these assets. And again, those when you properly fund your trust, you will avoid those court interventions. One thing I wanted to share is that we don't want to just the whole point of doing this is not just simply to avoid probates and court proceedings. Okay, there are many other benefits to creating a revocable living trust. I mentioned a little bit about the privacy here. Okay, so with a revocable living trust, when you pass away, okay, there is no requirement for you now to publish to inform the general public regarding your estate. How sometimes when we watch the news and when the celebrity dies, we find out, oh, this person got this person is because more than likely they would have had a will. And we talked about that in the last episode about some of the drawbacks of the will. Other benefits with regards to a revocable living trust is that in the event you have minor beneficiaries, you don't have to open up a conservatorship. There are provisions that are within the trust that will provide the safeguards so that way the minors now can still be the beneficiaries without us having to open costly conservatorships. Okay. You have the opportunity for designing your trust for creditor protection. So when you pass away, if we don't have, excuse me, let me take that back and reframe that. So the idea of creditor protection is this: we can design the trust in a way where now you can provide provision and guidance in there that one, they will provide creditor protection. As I mentioned before, the two things that we don't know is one, we don't know when we're going to pass away. And secondly, we don't know what position our beneficiaries are going to be in. Meaning, if they're going through a divorce, they owe people money, they're being sued, they get it. So all of these life situations. And in order to protect that, okay, we can design that within the trust. Now, with regards to incapacity, another benefit is the families or the grantors can actually create their own disability panel, basically take control. So rather than have a doctor or a judge decide, the grantor now would pick their disability panels. Usually it's going to be the people that care about them, that know them the best, that they now collectively would make that determination as to whether or not that individual is incapacitated. There's an opportunity to design value promotions, such things as marriage, going to college, buying a home. Or on the other hand, if you have a beneficiary that has some vices like gambling or drugs, value promotions that says they have to stay clean and sober. So, and then another benefit is with remarriage provisions, okay, we can design an estate plan to allow for now to include remarriage provisions. So as a lot of the families nowadays traditionally look more like blended families. And the idea of remarriage provisions is this: when I'm going to use myself an example. Okay. So me and my wife. So when we create this trust, I go, when I pass away, okay, I want her to continue to be happy. So, my spouse now, if she does decide to remarry, first of all, I can't stop her from remarrying. Okay. The remarriage provision would basically say, honey, if you do decide to remarry, okay, you and your new spouse have to take out a prenuptial agreement in order for you to continue as the beneficiary of our trust. So in essence, I want to protect what we created to leave to the people, to our children and our families, and not have it be all complicated with, the other spouse, the new spouse, in the event they get divorced, they have other children and yada, yada, and so forth. So I think that's pretty eye-opening with regards to, when you look at the makeup of families nowadays. The next
and the fact that you are allowed to put in all your instructions in advance, because like you said, it's all about what you want, right?
Yes, it's always going to be the exercise of control. And
Yes.
there's so much more, that's not on here, like how we work with the families. It's really identifying like what are their goals, what are their wishes, what are their needs, and how do we customize it to fit? And it is the exercise of control. The
Yeah,
next
because
document,
well, and as you mentioned too, with the children, right? Sometimes, young adults get into trouble and they bounce back, and you never know if they, go down the wrong path again. And instead of having them as a beneficiary, with an amount of money maybe that they've never had before, and without financial education, there's a possibility that if it went straight from, just an inheritance in a lump sum, it's something that could be lost, and lost quickly. So with this, I think you said it was called value promotion.
yes.
Is that what it's called? So that's where all of your instructions can be, whether it's for your children, your spouse at the time, or what have you, any beneficiary, you can put your instructions in there.
Yeah.
Okay, great.
The next
Thank you for
document
that.
I wanted to share was the certificate of trust. Okay, excuse me, sorry. I wanted to make sure we get through all the documents. So I know we have our limited time. So with the certificate of trust, also known as a short form trust, it's really meant to maintain your privacy. The certificate of trust is essentially a 2 3 page document that contains all of the necessary information that is needed now for third parties. So, for example, like when you are going to the bank and say you are going to change ownership of your accounts, so that way now you're funding your trust, rather than give the third party bank, like your 70, 80, 90 page trust document, you can simply take this short form trust, which is again a couple pages, and that should suffice. Okay, so it's just a verification of your trust. The next
Right, great.
document is your pour over will. Is actually a special type of will. It's a safety net. We hope that we don't ever have to use the pour over will. Essentially, what it does, it assures that the terms of your trust will govern the administration of your assets. Okay, so uh, in the next slide, we're going to illustrate what that basically means. So with a pour over will, as I mentioned, we hope we don't ever have to use it. So we created a trust in the event that the grantor failed to put an asset for whatever reason. Okay, there was this property or this account that was not put into trust. Okay, it's likely now that you have to go to probate. So what the pour over will does is the pour over will now allows for this person called a personal representative to go to probate court, essentially let the court know, court, whatever thing, whatever asset, whatever property that was not put into trust, go ahead and pour it over into my trust. Essentially, now the trust becomes the beneficiary of those assets. A couple other things that the will does that your trust will not do is one, the will allow you to nominate guardians for your minor children. And secondly, allow you to provide memorial instructions with regards to whether or not you want to be buried or cremated.
Is this pour over will a part of every person's estate plan when they create their trust?
It would be part of the estate plan. I mentioned earlier, if we are missing, and then this is, we said that before, and I'm going to say it again because in all the workshops and seminars that I do, we always address this. Many people, when they say, "Do you have your estate plans done?" We always go back to the will misconception. The idea now is that I have a will, and therefore I don't have to worry. Like everything will be taken care of if something should happen to me. And so when you say is a pour over will something that's a part of estate plan, my answer to that would be yes. It is necessary because there are certain things again that it does that your revocable living trust will not do.
And if you have a pour over will, and like you said, is sometimes people forget to put some kind of asset into their bucket, right? So say there was a new property that was acquired, and then this person did not fund their trust, and this person passed away, then this pour over will avoid the probate.
It actually will
probate
still
process?
go to probate. It will still go to probate because the property was not in trust. It's just that when
Okay.
when it goes to probate, you have a will that says pour it over into let the administration of this asset be through my trust. So the trust is the beneficiary. You're not going to avoid the probate. A probate proceeding will be open because the asset, the real property, was not put into trust.
I
So it's a
see.
safety net. And again, when we design this, we hope never to need to use it.
Mhm. Okay.
The next
Thank you for
document
that.
I wanted to share is the durable power of attorney. So now your durable power of attorney will become in effect when you've been deemed incapacitated. And the key thing here is in regards to non-trust matters. Okay, so you go, what does that mean? Well, when we create your estate plan, okay, when we do your revocable living trust, we would have addressed as you fund your trust, okay, you have a trustee, and then your trustee will be able to administer your trust as to only the assets that are in your trust. So now, in the event you're incapacitated, and like our pour over will, there's something out there, okay, an asset that was not put into trust. Your trustee actually has no authority to be able to now exercise their duties and go, okay, I want to do something with regards to that asset. Okay. You need a durable power of attorney for these non-trust matters. So in the event, like I said, there was an asset that was left out, your power of attorney agent can go to, say, the bank and say, bank, that asset that was not put into trust, go ahead now and put it into the trust.
If you didn't have a trust to begin with, the whole probate process, but having this pour over will and say something wasn't funded, it still would go into probate, but having this pour over will minimizes the time and the cost of that whole entire process, correct?
I'm not sure it so much minimizes the time and the cost. It makes it a lot more, let me say this, because the time we really don't have control of, right? We don't know what the calendars kind of look like. It will require time. It's just, there'll be less fighting, because the documents will clearly state what it is your intentions are. Okay. Now, even with the power of attorney, okay, it will allow you, because if you don't have a power of attorney, okay, what's going to happen is if it's in regards to assets, you have to now get a conservatorship. That requires a petition to the court. That requires the appointment. That requires all of the cost that comes with acquiring or being appointed as a conservator. If you have your durable power of attorney, we actually circumvent all of that because you can take this power of attorney, and it's actually by law now since 2015 that if you do have a statutory durable power of attorney, you can go to the banks and they are not able to refuse you in terms of what you want to do.
I see. So that's the reason why, too, that I know that you stated the last time that you should review to see if there are any updates that are needed every 3 to 5 years.
Yes. Because there will be, again, sometimes changes in the laws, changes in your family dynamics, in your life circumstances. Yeah.
Okay,
So,
let's talk about advanced healthcare directives next, and you can bring up the next slide, please.
okay. So the next document, like you said, was an advanced healthcare directives. And the purpose for your advanced healthcare directives is two things. Okay, one, the first is for non-end of life. In the event now you are not able to effectively communicate or consent to medical procedures, you will appoint what we call healthcare agents, and these healthcare agents would be able to act on your behalf. The second thing that Advanced Healthcare Directive does, which I think is so important because so many families, this issue could break families forever. And the idea is end of life memorialization. You have an opportunity now in the event that you've been deemed to be in a permanent vegetative state, 100% that you're incurable, that you're not coming back with regards to life prolonging procedures. You get to say what it is that you want. You want them to just pull the plug, let me go. You can elect to say that, no, keep me alive as long as possible because there are medical and technological advances. Or third, give me a couple days because a miracle may happen. And at the very least, allow for my families and my friends to come pay their final respect. I've seen too many families, like I said, broken forever because someone had to carry that burden of making that decision. And I don't think that's fair to any family, okay, to have to decide that. So the last document.
Right, with the parent that has more than one child, the siblings may disagree on what they feel the parent would want, right?
Yeah, imagine that, right? Like, right, a statement that says you killed mom versus this is what mom wants, and that, look, again, that family's forever broken. The last document that I wanted to bring up, I know we're short on time, is your HIPAA authorization. And essentially what this is it's giving permission, giving consent because your medical records are confidential, that allows for all of your trustees, your agents, and also our law firm the ability now to access your medical information to assist with the administration of your trust. And that together would be like what we call an essential estate plan.
Thank you, Amphay, for sharing all of this information with us today. I did my estate planning with Estate Planning Group, and I did it with ease and comfort. So I want to thank you for that whole process. And people don't plan to fail, they just fail to plan. And in estate planning, that is not an area where you want to fail to plan. So plan ahead, plan for your future and protecting your assets, protecting your money, and go from zero to millions. So I will see you on the next episode of Money Talks.
Thank you so much for watching ThinkTech Hawaii. If you like what we do, please like us and click the subscribe button on YouTube and the follow button on Vimeo. You can also follow us on Facebook, Instagram, and LinkedIn, and donate to us at thinktechhawaii.com. Mahalo.